Hello everyone, and welcome to today's webinar on risk management. My name is TJ Beemans, and I'll be your moderator. I'm the Executive Director with the Saskatchewan Association of Recreation Professionals, and I am excited to be hosting today's session. I'm pleased to introduce today's speaker, Aron Bookman. Aron is a lawyer with Caffra Lawton LLP in Victoria, BC. His insurance defense practice covers a diverse range of claims that often involve multiple parties facing potential liability. Insurers, municipalities, regulatory bodies, and institutional clients all turn to him for claims involving construction, fraud, municipal liability, personal injury, employment law, and human rights. Before I hand the mic over to Aron, I have a couple housekeeping items before this webinar starts. First, this webinar will be available on demand after the live session today and will be available through a link on our social media channels and website, sarponline.ca. Next, we'd love to hear from you during today's session. If you have a question for our speaker, please feel free to send it through the questions tab at the bottom of your screen. We'll be answering questions at the end of the session. If we don't get to your question during today's webinar, we will be sure to follow up afterward. So without further ado, I'd like to welcome Aron Bookman. Aron, over to you.
Okay, thanks, TJ. So thanks again for inviting me to speak to this group. One of my main clients in British Columbia is the Municipal Insurance Association of British Columbia, which insures a wide range of municipalities in this province. Also, I do work for municipalities that are self-insured or insured through other means. So municipal law is a big part of my practice. And as part of that practice, I do a lot of tort claims involving injuries sustained at facilities or fields or whatever you might want to call facility for a municipality across the board. And speaking with TJ, my sense of what this group might be seeking is a bit more information about how we look at dealing with managing risks in British Columbia through the facilities operated by municipalities. And I thought in doing that, I'd take a close look at the recent case involving the pool, University of Regina, and the terrible injury suffered by the plaintiff in that case. And I'm going to kind of walk you through how that risk might have been managed a little bit better, or differently, I should say better, had there been perhaps some other mechanisms in place to shift some risk. That's not to say that you don't shift the responsibility to maintain your facility. It just has to deal with how you deal with the risk side of the entire endeavor. So just a bit about me. TJ knows me through the Child Nature Alliance of Canada, which basically deals with kids and play. So you have a picture here on my first slide of me with my kids on a very unusually frozen lake in Victoria. And that's just my point. I'm a person who likes to be outside, a person who likes to be active and physical, and I try to do that with my kids, and I try to do that in my work at some level by essentially trying to assist municipalities and others in having facilities, having perhaps risky play and facilities involved in what they do, but also managing the risk. Oops. So I thought I'd first talk about the Beletsky case, which I'm sure you've all heard about, where a jury awarded a young lady over $9 million. And I know you probably know these facts, but there's not much that I can glean from the newspaper articles that you cannot. But I just put this quote on the first slide from the plaintiff herself, indicating kind of what she was most concerned about, which is that she says, I think it's finally recognized that it wasn't fault on my end or the swim clubs. I think we all knew all along. So the concept here is fault or blame. And it seems it was quite important to Ms. Beletsky to not be blamed for her own injuries. And our tort system in Canada, and the same is true in Saskatchewan, is a system where you look at the blameworthiness of the various individuals involved in a particular incident. There could be no liability or no blame on a defendant, and there could also be blame that's shared all around. But you can see from this quote that there was quite a concern from her perspective about her own injuries being her own fault, which is part of what the university likely argued, and part of what they also argued was that it was the fault of the swim club. So just looking at the facts of this case for a moment, you can see here at the second slide, the University of Regina appealed the decision. And the quote I gleaned from the newspaper articles was that there was a new drill to the senior swimmers where they dove out far. And obviously she broke her neck apparently as part of this drill. Now, you should know that I'm a swimmer. I swam competitively essentially through the United States where I grew up, and swam almost to university level before I decided to stop my competitive career. The bottom line from my perspective reading this case is that as a swimmer, I struggled with the concept that a skilled swimmer could not dive safely within, in essence, 4 feet or less of water. That's something that a swimmer who is skilled in competition, in my view, is able to do. Something happened here, obviously, and this young lady broke her neck, and that's awful. And I guess my suggestion to you folks on the line is that these types of accidents, they do happen, and they can happen in all manners of ways without blame or fault to be attributed to anybody. But the likelihood is that the more serious the accident, the more likely is there will be a lawsuit about it. And in this case, obviously, there was. And you can see that there was quite a defense mounted here to shift blame to the university rather than to the swim club. And I'm going to show you ways they could have dealt with that perhaps differently. Maybe they did, maybe they didn't. But I'm going to show you ways that I would suggest that they could have maybe avoided some of these arguments, or perhaps in the future shift the responsibility a little bit differently. So generally speaking, we have a lot of facilities that are operated, at least in British Columbia, I assume the same as Saskatchewan, that are municipal facilities or land, school facilities or land, or university facilities or land. And there's private clubs that use these facilities. Now, private clubs are typically not-for-profit clubs or societies. Sometimes they are paying corporations or whatnot. But generally speaking, you understand what I'm talking about. There's two ways that essentially I look at this and say you can deal with perhaps avoiding these types of claims or shifting the claim elsewhere. The first is a waiver and or informed consent model. And I'll go through that briefly here. That's an entire focus area for my practice is waivers and informed consents. And I've designed informed consents for the Child Nature Alliance of Canada for its forest school. I use them all the time. I have a whole presentation I do on that whole model as it applies to municipalities so that I can kind of walk through and raise those issues in a different way. But I'll go through that briefly today. I'll spend probably more time, I hope, on the issue of a contract between the swim club and the city, which could have included indemnity and insurance clause. Now, this might have been there for all that I know, but I'm assuming it was not. And so I'm going to focus on this as if it was not there and show you how it might have worked. So to give you some background, here's the BC Occupiers Liability Act. And so this act applies to any occupier of premises. Occupier is a legal defined term. It doesn't necessarily mean owner. You can have more than an occupier of a premises. So you could have an occupier being a municipality, and also the occupier being perhaps a club or some other group that essentially runs the facility itself. You can have, in essence, 2 occupiers or even more. But you can see the basic premise of the act, and I'll show you later how that's basically teased out of the common law, that it's a reasonable standard of care. And the idea is, I've underlined here, they'll be reasonably safe in using the premises. And you'll see here that it applies to condition of the premises, activities on the premises, or conduct of third parties on the premises. This is a pretty broad piece of legislation, which is pretty typical across the country of what these acts look like. Saskatchewan, to my knowledge, is the only province without an act. And I found that quite remarkable. And I had to have my associate here, who was licensed in Saskatchewan but moved here, confirm this for me because I wasn't aware. So Saskatchewan is living out there kind of on its own, with its own case law being developed, which is different from other provinces. Now, the common law is very similar to the Occupiers Liability Act, but not the same. And what I suggest is different is that the common law really distinguishes between the types of people who are in a facility. Distinguishes between people who are invitees or contractual entrants, etc. I'm going to show you these terms. I don't expect you to understand them today if you don't already know them, but I'm going to suggest to you that the common law includes a higher standard of care for invitees who pay a fee for access, which probably applies to municipalities in large part in their facilities. So I suggest it's like municipalities have this higher standard of care. And I also would suggest this leads to unpredictability of outcomes, as you saw from Beletsky. So in Beletsky, the issue was who, if anyone's at fault for this incident happening. And the fault lied in the idea that the pool may not have been actually, I guess, deep enough because there's water evaporating and not being tracked throughout the days. And that's the standard they were held to, was a very high standard of care to essentially monitor the depth of the pool, ensuring that it was completely within what they expected it to be. And if they couldn't prove that, they were found to be at fault. So here's a statement that we pulled out of a recent Saskatchewan case, occupiers liability law. And you'll see quite a similarity between this statement of law by a judge in Saskatchewan and what's in the Act in BC that I showed you a moment ago. So the same reasonably safe terminology is used. And there's a little more language that's a bit more tied to the common law, but in essence, you have a reasonable standard, I'd suggest. But then you get into invitee, and a person who lawfully enters an occupier's premises for business purpose, common to both, is an invitee. Then you have contractual entrant, who has contracted and paid for the right to enter the premises. So they use the sporting events example, but there's other examples, and the case law says that a contractual entrant need not pay for it per se. There can be all manners of way that there's consideration given one way or the other for entering the premises. So here's the standard of care for invitees. And what the language here says is prevent damage from unusual danger, which the occupier knows or ought to know exists. In the BC Occupiers Liability Act, that unusual danger language is actually reserved for places such as recreational trails. So it's interesting that essentially invitees, unusual danger comes up in this way in the common law. So you'll see here that the idea of unusual danger is that the person who's occupying is entitled to assume an ordinary reasonable person would know what they're going to encounter, or essentially look what, see what, they would basically look where they're going and see what's there to be seen. That's the idea. But then you have this kind of shifting between invitees and normally expect to find. I just want you to read this language and think about how this language can be argued both ways. What is an unusual danger? Obviously, if you're the plaintiff and you've hurt yourself on a facility, on a field, you'll argue that that was an unusual danger. Whereas the person who occupies the field will say, well, that wasn't unusual, it was there to be seen. So these types of arguments are there. They are done within the common law context, and a judge, or in this case of Beletsky, a jury, decides. And that's the unpredictability of the entire exercise. So here's the contractual entrant standard of care. And you'll see I underline this first part, that there could be a contract expressly prescribing the obligations of the occupier in relation to safety. Now, I don't know how that's been applied in Saskatchewan as far as whether it's been applied at all with municipalities and perhaps some type of document such as a membership agreement when you join a facility. For example, the city of Surrey has a waiver on its actual membership agreements that it sends out to people who buy memberships for their facilities. They actually tested that agreement once in court in a small claims case, but the judge didn't rule on it. But they have that sitting there, and I've always wondered what would happen with that. But predominantly, I suggest that most likely the actual contract is silent on the matter. So then you have this implication of being safe for the purpose as reasonable care and skill on the part of the occupier can make them. So this imposes a duty of care and a standard of care. And the standard of care is reasonable care and skill. And what that means, of course, is another area of argument. And you could see, for example, the potential for people who are experts in the field to give opinions on what was reasonable in the circumstances. In this province, for example, when I'm doing a case involving slip and fall on a pool facility, I often have to have an expert look at the slip resistance of the area and tell us if it's slip resistant or not. The other side will get their own expert and they'll have their own view on that. That type of work can be done for all kinds of places on schools. In the Thompson case I did, which is a Sandwich case, which you may have read, and if you want to read it, I can send it to you. The issue was essentially, was the entire exercise safe? And one issue was the playground safe? So you can see how this issue of reasonable care and skill really becomes an issue that's hard to essentially define and becomes something that both sides can argue depending upon the incident. So thinking about the idea of contract, that leads into the idea of a waiver. And so I wanted to send out for you and BC where this law has gone. And I'm not expecting you folks to use waivers essentially for your facilities. I'm not expecting you folks to have a waiver system in place. I'm going to suggest to you that if you're running essentially more high-risk activities, such as having a climbing gym, things of that nature, you probably should have a waiver system in place. But generally speaking, I want to make sure you understand this principle, and we can kind of go through it on a case-by-case basis if you folks need that assistance. So Loychuk is the key case in British Columbia involving a zip line. I'll show you the facts of the case in a moment. But the point is this is the Court of Appeal in British Columbia, which says very clearly in 2012, there's nothing wrong with waivers. It's not unconscionable for the operator of recreational sports facility to require a person who wishes to engage in activities to sign a release that bars all claims for negligence against the operator and its employees. This is a big deal. There's nothing wrong with doing this, and this is a big deal in British Columbia. That case law is also being relied upon in Ontario, and I think that's the pervasive view across the country. So I just wanted to also alert you to the fact that these types of cases are really hard to predict. They come up all the time. So I have a case here called Dominelli versus Sandwich, which always has driven me nuts. And I'm not going to spend much time on it, but the bottom line is that this swimmer was in our Commonwealth Place competition pool. And there's this Commonwealth Place in Victoria, if you haven't seen it, it's a big facility. It's an Olympic style facility. And it basically has a number of pools, including a competition pool that's 51 meters in length with a 1 meter bulkhead that's movable. So this bulkhead typically is set up in the middle. So it sets up two different pools to be used for practices, water polo, swimming, or just for people to swim recreationally. People use the other side of the pool for something else. So what happened here is the swimmer who hadn't been to the pool before was practicing her underwater swimming. And she was approaching she expected this T at the bottom. If you're a swimmer and you watch the bottom of the pool, there's the black lines, and it ends in a T close to the edge, telling you you're close to the end of the pool. Well, this is a 50-meter pool, so the line, there's no T, it just carries on. And so she's expecting this T, and she smacks her head on the bulkhead. And this case drove me nuts because when I read this case, which was argued by a friend of mine here in town, I knew as a swimmer it didn't make any sense that you would see the bulkhead it's there to be seen. And this basically says that the swimmer was really not paying attention to where she was going. And now there's a problem with the pool, and there's fault assessed against the municipality for this incident. So I just want to show you this case. There's mountains of case law in British Columbia all over the map on these things, and they're quite unpredictable. So I do have some good news, though, that our courts in British Columbia have been very clear about there not being a duty to warn about things someone should already know. So I'm going to briefly go through this case called Duddle. This is a pier in Vernon, and they have this beautiful beach and pier in the summer, and it's quite popular. And that people use it to hang out on, and then of course all these signs saying don't dive, you might break your neck. Well, guess what? Someone did. So this fellow named Mr. Duddle, who grew up in Vernon, dives headfirst into the water and breaks his neck, and he's sued. And the Supreme Court judge was very sympathetic to his case. And you'll see I quoted from one paragraph of the judgment. And the judgment is quite harsh in the sense, in my view, in the saying this probably did not do all it could have done prevent this accident and all of the circumstances. You'll see in a moment that the Court of Appeal overturned this decision. But the bottom line is that this guy was really badly injured, like Ms. Beletsky, and like a few other people that I could point you to. And I got another one here coming. And the Supreme Court level was quite sympathetic, I suggest, to his plight, and in essence reviewed all these facts about what had happened, and had issue with the fact that the municipality didn't have people on the pier actively warning people not to dive off of it head first. And that's what this judge found, and here's what happens. The Court of Appeal disagrees. And so you can see here the Court of Appeal says that there's no liability because this was a danger he should have known about. It was obvious. So the sole cause of this incident was Mr. Dell's failure to take reasonable care for his own safety. So I'm just putting that there for you to think about in the context of Beletsky, and a case I'll show you in a moment, and to show you kind of how these issues become quite challenging in the sense of a known risk, duty to warn, negligence, all these terms that are thrown at you. The bottom line is that there's been an injury, and sometimes that injury dictates the lawsuit. So I'm going to talk about Campbell, and I'm moving kind of quick, so I want to get to the end piece, which is the contractual piece. But Campbell is a case involving a mountain biking park and this other park they'd had for these events. So one theme that I have for municipalities is municipalities becoming quite, I think, engaged with the community and putting in facilities that are actually riskier in the sense of than a normal playground facility or just a trail. So in this case in Ontario, they put in this big mountain bike park, which was free for use. They also put in this area with these elements to try out your skills. So the red circle here is the one this guy actually fell, Mr. Campbell fell on and broke his neck. And the case is detailed. I won't do it in detail, but the bottom line is he broke his neck, he sued, and it went through the Superior Court level in Ontario and Court of Appeal level in Ontario, and the plaintiff succeeded. And in essence, what happened was he goes up this teeter-totter, and he goes off a bit and breaks his neck. And the response from the municipality was, well, that's a known risk. He should have known that going up to it, and it's not our fault that he broke his neck. So I'm going to skip this slide, but it just basically has some information about what this park was and what it consisted of. And you can see here on this next slide, the judge was worried about the dual risks with this free fall apparatus. You could ride too slow, lose momentum, or ride fast and be launched off the end. And the respondent, the municipality's person in charge of it, who's actually the picture of the fellow I showed you a moment ago, he insisted that users had to self-assess. And the judge didn't like this and said, in essence, how would municipality know that there weren't novice riders or hadn't done this before, and the self-assessment wasn't enough? Those people might not be aware of the skills they needed, and in essence, essentially found that they had a duty to warn. So there's some paragraphs about duty to warn. And I ask you to, if you read through this later, to think about facilities you may have and how unpredictable it is, whether or not a warning will essentially be reviewed and whether or not it'll be sufficient. Because this case doesn't say precisely what they should do to warn people. It just says there's a duty to do so. And it just critiques what was not there and does not really go into detail about what was there. So you can see here that there was no warning of serious injury. That was something that was prevalent in the judge's decision. And so in essence, the issue here was there was not adequate warning to Mr. Campbell that he could break his neck falling off this piece of equipment. But what about Duddle? I showed you Duddle a moment ago, and Duddle was argued essentially by the municipality in this case, where they said, well, hold on a second. In this case, in British Columbia, a person dove into shallow water and broke his neck, and the judges said, we don't have to warn him about that risk of injury. And this judge didn't find that persuasive, and instead found that the dangers here were an unexpected danger. You may recall the language earlier, the unusual hazard. So those words seem to marry. So that's the issue here, this other one here about hidden danger. So if you think about this and put it in the context of occupiers law in Saskatchewan, this same language would ground fault in Saskatchewan for a similar type of apparatus or activity. And the Court of Appeal, of course, also upheld the decision. And so I just have a few lines here where the Court of Appeal basically said that, nope, we're content with the decision of the Superior Court judge, and we uphold that decision. So putting that in context about waivers real quick. So adults can waive their right to sue. And I'm going to show you some case law in a moment, and I'm going to juxtapose the BC case law on mountain biking with the Ontario case that we just saw a moment ago. And the key point here is that if you have a waiver in place in BC with an adult participant, you often get the case done at a summary trial stage. So that's not a full trial, it's trial on paper, which is far less expensive. People still sue, but you can kick the case out earlier. So this is the Loychuk case, and there's a picture here of the Cougar Mountain zip line, which is in Whistler. And you can see here, this is a very long zip line. It takes minutes to get across. And so what happened here is this fitness instructor was injured when the zip line guide sent the second person down, who was also a law school graduate, too soon. And that's obvious negligence, and they admitted it because you have a radio back and forth. But the case was dismissed based on the waiver, and that was upheld at the summary trial level and upheld by the Court of Appeal. The Supreme Court of Canada dismissed the application for leave to appeal. So that's the case law in British Columbia, which is still being challenged every day. So recently we had a case called Jameson versus Whistler Mountain Resort Limited. And this involved a mountain biking incident, very similar, I'd suggest, to the one in Campbell, where this fellow broke his neck going down the A-line rock drop. He was an experienced skier. He worked as a volunteer, ridden the course before, and of course he signed a waiver. So this is what this looks like. And I did go online at one point and looked at this, and a lot of folks were falling off this particular part of the course. So this judge, Judge Adair in British Columbia, she looked at the entire case in front of her, argued by the same lawyers who argued the Loychuk case, and in essence found that the waiver was sufficient. And she found, in contrary to what you heard from the decision in Campbell, that the argument that the release must warn of the specific risk of a spinal injury or being thrown over the handlebars did not succeed. So this is important because you can see how unpredictable all of this is, how you can have a waiver and it really helps you, how without a waiver in place, you have this piece of the case that isn't there to help you and vice versa. But the bottom line is that you have inconsistency in these various concepts and decisions, which is hard to reconcile, which creates risk. That being said, it's my view that waivers and releases are not a good fit for facilities, generally for municipalities. And I can see how municipalities might not want to involve themselves in some type of robust waiver situation, except for certain things they do. And I'm in favor of that. And I can go through that whole presentation another time if you want. But the bottom line is you also have children using these facilities. And in BC, at least, I assume the same across the country, children cannot waive their rights. There's indemnity agreements that are a workaround, but that is questionable to me. And to contract out the duties under the Occupiers Liability Act, you have to be explicit. But then again, I say, if you're operating certain facilities like rock climbing, you should look at waiver systems. So that leads me to the next point of the presentation, which is, I think, the key issue that we want to discuss today, which is municipalities having facility users have an agreement for events or club use. And these organizations that organize these events, they typically are insured. And if they are not insured, they can obtain insurance. There is a huge market for insurance in this country. And particularly for activities, these are not hard policies to obtain in my experience, and they're not overly expensive. They typically are run through either one of the domestic insurers, or a broker will go to what's called a specialty risk market through the Lloyd's market, and they will obtain this type of insurance. So when people are concerned about a club or other activity person or event organizer not being worried about the event happening or the club will operate without insurance, in my view, that's not really something that's valid. I think that every organization or event organizer should have insurance or consider insurance at very least. And it's not hard to obtain. Now, municipalities, of course, have deep pockets, and that's why I think municipalities are targets in this tort area, and the University of Regina as well. So most general liability policies that are held by organizations, societies, or corporations have at least $2 million in liability coverage. But you really should think of 2 million as a very low floor, in my opinion. For a modest price increase, you can get $5 million. And there's a move towards 10 million, which you can see from the Boletsky case would have barely covered the case in that regard. So on the issue of how much to require, I think you should require at least 5 million and perhaps as much as 10. But that's something we can talk about another time perhaps. Now, I asked TJ about what you folks do for insurance in Saskatchewan, and I gather there are programs that are somewhat similar to MIABC, which is SARM and SumaSure. And I don't know this, but I'm assuming that just like in British Columbia, there's different models you can choose. And the models typically involve what I call a self-insured retention in the range of $25,000 to $50,000, which includes legal fees. So in other words, if a claim happens, the way that works for me with MIABC, and I assume works for you folks, maybe not, is the MIABC manages the entire claim with the help of the municipality, either through a CAO for a small municipality or risk manager for a bigger one. But the first X dollars of my work is billed directly from MIABC to the insured municipality. And so I know this, and I know that for a lot of the work that I do, while I'm getting paid by the insurer, I know the first chunk of money is the municipality's money. And that it's important to know that as a lawyer, because it does essentially tell me what I have to do with the initial level. And sometimes I just have to tell the municipality, this money will be spent. And then they're okay with that, and they turn the whole thing over to the MIABC to run it. Some municipalities that are more sophisticated have other types of programs in place. They go to a broker and they get insurance through the Lloyd's market or through, I think, Travelers has municipal insurance, or they self-insure. They have, for example, $2 million in self-insurance, and then after that, they get reinsurance for bigger claims. And so there's all kinds of models, but the bottom line is that this type of risk management has to happen. So what I see happening and what I recommend is that you should have some type of contract in place between the municipality and the user groups. And some of this has been in place for years and years and years as far as relationships. It's okay to change it and make it a contract. There's no harm in having that there. And in fact, I think it really needs to be done. And the event insurance for people running just one event, either annually or just one event period, is not that expensive. And what this does is it can transfer the risk through the contract, but also through the insurance clause. And this is the important piece I want to convey. The contract can have an indemnity clause, which basically says that if something happens, the event organizer or the club indemnifies the municipality for what had happened. And that indemnity is, of course, a very important thing to have in a contract. But the even more important clause and the more important documentation is to make sure that the municipality is an additional insured on the user group's insurance policy, because that forms a contract between the municipality and the insurance company. So you can have a situation where you have an indemnity but no contract with the insurer, and the insurer can say that's not our problem or can argue around the indemnity. But where you actually are an additional insured on the insurance policy for the user group, that's a direct relationship, and I'll show you that in a moment. So we've had a lot of litigation in this office revolving around the use of facilities by user groups and the insurance contract between that user group and the school district or the municipality or the university, for example. And I've only given you a few of these cases here, but it's a constant issue that we encounter. I have a case right now that I'm managing to hopefully move off from the municipality's insurance policy to a softball association policy involving an incident where a young girl slid into, tried to somehow broke her ankle because she slid into a post for a base on a baseball field that wasn't covered up with this mushroom cap to make it soft. And that's the fault, I suggest, of the club. But the bottom line is that the municipality at this point has been sued. So I'm trying to shift that over. So this is one of the first cases that we handled here in the office, and it's, I think, a pretty typical example. So this Apollo Hockey Club had a baseball tournament they ran at the school district field. Mr. Mayo essentially broke his ankle stepping into something he called an irregularity on the field, a minor hole. There's another case too we had where the guy was playing in the outfield, and he essentially was running for a ball, and he went from the grass to the concrete and broke his leg really badly. So I just chose this example to show you what had happened, because we litigated this one, and they took over the defense. So what happens then is that there was an event policy where, sorry, an event agreement where in essence the folks at the hockey club agreed to indemnify the school district. And also there was a certificate of insurance, which was on the Lloyd's policy for the event, which added the school district as an additional named insured. And this was one of the first, and it always struck me that what Lloyd's was trying to do here in opposing the application and saying they didn't have to defend the school district, was I always wondered, what value did this policy have to the district if Lloyd's was right and they didn't have to defend the district from this action, only because the issue was actually what was on the field as far as some type of hole in the field versus something else. And that always struck me as a pretty clear indication that Lloyd's, in my view, was not adhering to the contract it had with the school district. So Lloyd's basically tried to draw a distinction between the occupier's duties of the district and what had happened in the tournament. And so they said this didn't arise out of the operations out of Apollo, but instead the district obligation is the owner of the field. And they made the point that this duty of care owed by the school district was a duty of care essentially that was in the air. It owed that duty of care to everyone who might use this field, whether a tournament was there or not. And the judge says in this next paragraph I've quoted here, there's some logic in the position, but she says, this is Justice Wedge, she says, no, that can't be true, because the incident was so closely associated with the activity of the hockey club. And she provides a scenario here that's something that might have not fallen within the hockey club activity purview. And I don't know if this is right, but she says, well, what if he was just kind of walking around and a roof tile fell off and struck him on the head? She could see distinction there, but not when it comes to playing baseball, which is what the activity was at issue. So she found that the pleadings in this case, and that's the key point, the pleadings in this case, and I can tell you how that works another time, clearly connect Mr. Mayo's injury closely to the very activity that Lloyd's agreed to insure. Mr. Mayo would not have injured his ankle but for the Apollo decision to put on the tournament, and that's the key distinction here. So how does that work? And I'll show you. So what that means is that Lloyd's had to take over the defense of the district in that case, and we never saw the case again. We suspect it probably settles. So I've given you here as well, what I did was I pulled from my client Sanish's website. So it's not as if I pulled this from something they gave me otherwise, it's all publicized. Some pieces of their application for someone to use their facilities for either an event or more regular use. And this is an indemnity clause example that I pulled from them, which is something that they've had in place for a long time. And it's a good one, I suggest, and you'll see here there's all kinds of legal language here and jargon, but this is just an example for you. And then this is the more important clause in my opinion, it's the insurance clause example. And you'll see that you must have proof of comprehensive liability insurance, minimum amount of $2 million, which I'd suggest they might want to increase. And this other language is kind of particular as to what should be there within the policy, but you'll see how that works. And you'll note there's a line here as well that directs people to their own insurance broker and says they can give you this, or we can give you a form to fill out. So Sanish had this come up as well. And so Sanish is one of our clients, and we had a case involving a lacrosse activity at a multi-use facility. And I don't know if you know Victoria, but Sanish is actually bigger as far as land size and population than the city of Victoria. And it has a lot of facilities, and a lot of them multi-use facilities. And this one, I believe, was actually one which is which they separate with these kind of movable plastic sheets between the various pieces of the facility, so you can run essentially lacrosse on one piece of it. You can run, in this case, dog obedience class, another piece of it. You might have kids playing indoor soccer, another piece of it. And there's a few places like this, they call them field houses here, where they have these types of multi-use setups. So on this particular day, you had a dog obedience class on one part of it and lacrosse practice on another part of it. And this fellow was walking through and he gets hit in the head by an errant lacrosse ball. And he alleged fault against the lacrosse club and organization, and also saying they couldn't identify who did it. So they argued that the person who did it was at fault too. And they also alleged that Saanich was liable on Occupiers Liability Act for having unsafe premises. And the idea was that Saanich should have had a better system in place to divide the obedience class folks from the lacrosse practice folks, and it was dangerous to have lacrosse so closely connected to something else. So Saanich had a policy in place, as you saw earlier, and we have a certificate of insurance in place that named Saanich as additional insured on the Lacrosse Association insurance. And you'll see the language here, additional insured, but solely with respect to the liability which arises out of the activities of the named insured. And this is what became the argument here, is did this liability arise, quote, solely with respect to liability which arises out of the activities of the named insured? And that's the wiggle language that tends to be in these certificates of insurance that becomes an issue, but I suggest is not much of an issue. And so what happened here is Aviva, the insurer, denied coverage of Saanich, and it argued that the liability was not for the lacrosse activity, but due to the allegation that it should have provided a safe entrance to the area for the dog obedience class. And so it's similar to the one I showed you earlier, where Alex Egged was the lawyer for Aviva, and he said, in essence, well, hold on a second. This was an Occupiers Liability Act case against Saanich. It has nothing to do with the lacrosse activity, except that he just happened to be there for the dog obedience class and the lacrosse ball hit him. My colleague argued, no, that just can't be true. And the judge disagreed with Aviva, and I have a long quote here, but I've underlined the key pieces, where in essence, the court talks about the unbroken chain of causation. In other words, this lacrosse player was playing lacrosse. This fellow happened to be going through for another activity. If it was not but for the lacrosse activity taking place on the Saanich facility, this would not have happened. And so that's the point, is that when you have this activity type of going on in your facility, and you put in the insurance policy, if the activity leads directly to an incident, it doesn't matter per se who's at fault for the incident. It could be both Saanich and the lacrosse club. But the insurance policy doesn't really worry about fault between the two. The insurance policy is a contract. So the insurance policy then steps in to defend Saanich as opposed to its own self-insured money, which is how it works, which is a big deal. They've shifted this claim now to somebody else. So the important piece then is that Saanich succeeds. Aviva has to defend the case. And of course, just like the Mayo case, essentially this case settles in our understanding, and Saanich wasn't involved. And there's been a shift in the law in British Columbia, and I suggest likely in other provinces, and probably it would be adopted in Saskatchewan, where insurance companies deny coverage and they don't succeed. The current law is such that, if I was arguing this case today, I would have said to Aviva, not only must you defend this case, but you have to pay all of the legal fees we've expended to defend the case to date, and you have to pay for all the legal fees that we expended to bring this petition forward to the court to get declaration of coverage. So because Aviva defended this way, they'd be paying everything, and Saanich would pay nothing at the end of the day. That's the way that I think it would work today with the changes in the law. So practical tips. I really wanted to focus on user agreements and get you folks thinking about how that could work and how it's not a bad thing. That not only does it work, but you're shifting this to become a contract between the facility user and the insurance company, and also the municipality. So there's 3 parties to that contract. But the other thing I want to make sure that you understand is that the biggest problem I see with that type of practice is not having it put in place in the first instance, but it's keeping it updated. And so your staff has to be trained to ensure that they check for these every time. And it's not just a checkbox, that they know what the documents mean, and they're able to read them and understand them at some level, and ensure that there's not some wiggle language within the insurance certificate that somehow avoids fault, or somehow, sorry, not avoids fault, somehow avoids the coverage that you're seeking. And you got to make sure that every time that group that's been there for 40 years running an event every year comes around for the next year, that you get it updated. They may have let their insurance lapse. They may have forgotten to add you folks additional insured. And these brokers that do this type of additional insured work for their clients, most brokers can do it without any additional cost to the user group. They can actually do it most likely without even seeking any permission from the insurer. So this is all something that can be done pretty painlessly between the municipality, user group, and the insurer. But you got to make sure you keep it updated, and you got to make sure you have certificate of insurance in your records. Because the other thing to remember is this: you could have an incident that happened in your facility to a 5-year-old, and it could take 14, 15, 16 years before that accident actually becomes a lawsuit. I have one of those cases right now. So you got to make sure you have it, got to make sure you document it. These days you can scan it in, and that way you have it for age immemorial. Because these insurance companies, these brokerages, they change hands, and sometimes they can't keep track of stuff either. So that's the presentation I have for you folks today. I'm going to turn it back over to TJ. I spoke a bit quickly to get through the entire set of slides, and I'm happy to take some questions from the group.
Thanks, Aaron. It's an excellent presentation. If anybody has any questions, feel free to submit them through the question icon at the bottom of your screen. I haven't seen any come through yet. If there is no questions, that's okay. If you, I'm guessing a lot of people online will probably go back and watch this. There was a lot of information to cover. If you have questions though, please feel free to send them to myself directly, Executive Director at sarponline.ca, and I will be sure to fire them off to Aron and get some follow-up. So seeing no questions, we will end this session now. Thank you everyone for joining us today, and again, thank you, Aron, for your time. It was a great presentation.
Appreciate it. I appreciate the opportunity. Oh, there's one.
Oh, one just popped up here. So we got, the question is, what tips do you have for our open parks and natural trail areas as far as risk management?
That's a whole presentation in and of itself. So I actually have done a presentation that takes about an hour talking about parks and trails. And I would have to research how maybe it's done in Saskatchewan, but in British Columbia, recreational trails are essentially a defined term under the Act. So what happens is there's a lower standard of care for recreational trails that are marked as opposed to everything else, so to speak. So as far as the open parks natural trail area, as far as risk management, there's not a heck of a lot that I can say, you know, with that type of broad question. But you know, the bottom line is that, you know, we talk about in other presentations regarding signage. We talk about other types of things you can do. The key issue there is the policy operational defense, which is an entire subject in and of itself, and that's Supreme Court of Canada case law. So you need to set up policies that essentially define your procedures, and those policies are then the defense to a claim that might happen. For example, we've had a few cases recently in British Columbia involving trees falling on people. We had one really devastating one that happened and resolved about 1.5 years ago. I had a less devastating one, but I've had all kinds of cases in parks. We just did a big case actually on a cyclist in a local park here who hurt himself pretty badly. So this happens all the time. And the key defense is to ensure the policies are in place and that you follow procedures you define. And you can have unwritten policies, and you can defend on that basis. But in my view, if a written policy is better than unwritten policy. That being said, make sure that if you write policies and procedures that they are not aspirational, and that in essence you write ones that you can adhere to. And you can have a policy of no inspection, and that's key to emphasize here. Saanich has a no inspection policy across the entire municipality, purely responsive policy. And that has been upheld recently in a tribunal setting where we just argued a case for Saanich. So that's the answer to your question, that in essence, it's, in my view, the best way to manage those parks and trails is through policy, either having a responsive policy completely or some type of other policy of inspection procedures that you do adhere to.
That definitely sounds like an entire new presentation for the group.
Yeah, no, I've got an entire hour on that. But again, Saskatchewan may operate differently, but the Supreme Court of Canada law is quite clear on what the defense is.
Thank you, Shelley, for that question. Anybody else with some questions out there before we part ways? All right, seeing nothing, again, thank you everyone for participating, and thank you, Aron, very much for your time. We greatly appreciate it and hope to have you on again.
Take care, folks.
Have a great day, everyone.
Bye.